Welcome, everybody. We're so delighted that you're here today. Thank you for joining us. My name is Jen Mason McAward. I'm the director of the Center for Civil and Human Rights, and it's our real privilege and honor to be partnering with the Black Law Students Association and Notre Dame's newest student group, the National Lawyers Guild, for today's talk. And so I want to introduce you to Rashid Gilmer, who will tell you about our speaker today. Rashid is a third-year student here at Notre Dame, and he's been instrumental in not only bringing this speaker here today, but also in getting the National Lawyers Guild certified as a student group. So Rashid, thank you very much.
Good afternoon, everyone. So, as Professor McAward said, I'm Rashid Gilmer. Over here is a wonderful, wonderful man. Honestly, he's probably the one practicing lawyer that I look up to, bar none. He's has 50 years of civil rights experience. So he's ever since the Civil Rights Act was enacted, he's been litigating civil rights cases as a lawyer. He is a graduate of both Chicago undergrad and Chicago Law School. He's currently in Detroit practicing civil rights litigation at his firm, Goodman Hurwitz P.C. He also is a practicing attorney in New York. He was the legal director of the Center for Constitutional Rights in New York, and he spearheaded many cases against the president dealing with executive power and habeas corpus. So everyone, welcome, please welcome, give a warm welcome to Bill Goodman.
Well, I want to thank Rashid, and I want to thank the Center, and I want to thank the Black Law Students and the National Lawyers Guild. It's a pleasure and a great honor to be here at Notre Dame today. And I guess what we're going to be talking about is what it's like to try to practice civil rights law within the context of what's known as the Civil Rights Act, 42 U.S.C. Section 1983. Now, Rashid said I've been practicing law ever since the Civil Rights Act was passed. That's not quite accurate. The Civil Rights Act was passed in 1871. And although I'm always flattered when people say I don't look my age, anyway, the remarkable thing about the Civil Rights Act, that it was indeed passed in 1871. I still refer to it as the Civil Rights Act of 1871. It was passed within the context of the Civil Rights Amendments to the United States Constitution, the 13th, 14th, 15th Amendments. And the very first time that it was decided that people whose rights were violated by public officials, the key word under the Civil Rights Act is under color of law, the key phrase. It's under color of law. The first time someone was allowed to sue under that statute was 90 years later, in the year of 1961, which was a few years before I started practicing law, in fact. And that was in a United States Supreme Court opinion called Monroe versus Pape. Now, let me ask a few of you questions. How many of you have taken Professor McAward's class in 1983 and civil rights litigation? How many of you are taking it now? All right, so I apologize if I tell you things you already know, but at least it'll be familiar. To the rest of you, there will be time for questions. To all of you, there will be questions, I hope, at the end of this, and we can spend a little time talking about stuff. I'm going to try and keep my eye on the clock here and do the best I can. So I said, in 1961, the United States Supreme Court, Mr. Justice Douglas, wrote the opinion called Monroe versus Pape. Here is a paragraph from Monroe versus Pape. The complaint alleges that 13 Chicago police officers broke into petitioners' home in the early morning, routed them from bed, made them stand naked in the living room, and ransacked every room, emptying drawers and ripping mattress covers. It further alleges that Mr. Monroe was taken to the police station and detained on, quote, open, unquote, charges for 10 hours while he was interrogated about a 2-day-old murder, that he was not taken before a magistrate, though one was accessible, that he was not permitted to call his family or attorney, that he was subsequently released without criminal charges being preferred against him, unquote. Mr. Monroe and the Monroe family that was forced to stand naked in their living room while 13 police officers ransacked their house was an African-American man. The family was an African-American family. The cops were all white, including the named defendant and the person who led the raid, one Frank Pape, a detective chief. He was a deputy chief of detectives and a notorious racist, and that's what Monroe versus Pape was about. That was the first time anyone was ever allowed to sue police officers or public officials under Section 1983 of the Civil Rights Act. And one may wonder why it took 90 years to fulfill what essentially was the promise and hope of the 14th Amendment. And I think the answer is clear. It was the dominance of post-Civil War racism in the United States, basically, with all due respect to Mr. Justice Frankfurter, who wrote what in my opinion is a revolting dissent in Monroe versus Pape. But since that time, how much good has it done? That's the question you have to ask yourselves. What good has it done to have this kind of legislation where we're allowed to sue and we may or may not be successful? We read about large settlements all the time in the newspapers. Other than compensating the victims, and I don't mean to minimize that, that's terribly important as well. Well, since then, what have we seen in Chicago? We saw anybody here from Chicago? Other than the people from Chicago who I'm sure know about the Burge torture incidents within the Chicago Police Department. That went on during the 70s and 80s and into the 90s and was basically overlooked and forgiven by the top leadership within the city of Chicago and the Chicago Police Department. In 2014, what happened in Chicago? Anyone? Yep. And Laquan McDonald, does that name ring a bell with anyone? Right. And what do you mean it comes out?
Site that the police had used probably back into the work.
Right. And Laquan McDonald, this was a video which showed an absolutely unforgivable shooting by a Chicago police officer of a young African-American kid, which had been basically suppressed in order to assure the election of Mayor Rahm Emanuel. So, what good did Monroe versus Pape do? Well, we'll talk about that later. Maybe it did some good and maybe it didn't. One of the questions is, would things be worse without these kinds of lawsuits, with these threats hanging over public officials, and without the ability to force public officials to answer questions when they're asked those questions? And we'll get into that a little bit more. A few personal words on me. I have basically, as Rashid said, grown up with this statute, and I hope I haven't been as warped and wrinkled and tattered as the statute has been through many court decisions over the years, but I probably have been. In the summer of 1962, at the end of my first year in law school, I did go into the South and work with a small African-American civil rights firm in Virginia throughout the South, and it was a formative and inspiring experience. And as Rashid said, in 1998, I went to work at a place called the Center for Constitutional Rights in New York City, and we're going to talk a little bit about at least one or two CCR cases. And I stayed there until 2007, then returned to Detroit and have continued to do civil rights work. in the end, there is really only one way, well, there is the principal way that we can really affect police misconduct is through three operational methods that I can point to. Does anybody want to venture a guess about what some of those might be? How to change police behavior, how to affect police misconduct, how to use police misconduct in order to shape the future and prevent it. All right. Yes?
Perhaps we body cameras to actually demonstrate what police misconduct actually looks like.
Well, body cameras are a great and important device, and so are dash cameras, by the way. And we're going to see dash cameras in a minute if I can get my technical skills cranking here. But what I was talking about is really three more structural methods, and I'm talking about training, supervision, and discipline. Those are the three things that I think will really, in the end, alter and affect the way police respond to all situations. Training, supervision, discipline. And litigation, in my opinion, plays a role, if for no other reason, that it points out the lapses in training, supervision, and discipline that have resulted in what happened to Mr. A or Mr. B and what may happen in the future unless these things are changed. As I said, when I was in New York at the Center for Constitutional Rights, we engaged in important police misconduct litigation. Have any of you heard of the stop and frisk lawsuit in New York, which is now known as Floyd versus City of New York? We started that case when, I believe it was the year 2000, may have been 1999, I can't remember. It was originally called Puerto Rican National Congress against the City of New York. It then became a case called Daniels versus the City of New York, and ultimately ended as Floyd versus the City of New York. And we sought, the theory in that case was to try, well, let me step back for a minute. I was approached by a great community activist in New York named Richie Paris, who's now sadly gone. And Richie said, are people, Latino males, young males especially, black kids, are being stopped constantly by the New York Police Department. Is there anything that can be done with it? Now, up until that time, my view of injunctive relief for constitutional violations was shaped by a United States Supreme Court case called City of Los Angeles versus Lyons, in which the Supreme Court basically said, no, you can't stop, for, in that case, the use of chokeholds unless you can prove that there is a likelihood of repetition. So what we instituted in that case was an attempt to go into the statistics and see if, through statistically, we could show that if you're a young black Hispanic kid, a young Hispanic kid, a young black kid, you're likely to be stopped and frisked by the New York Police Department without reasonable suspicion, which is the trigger phrase, as you all know, from Terry versus Ohio, right? And so what we did was we got a really excellent statistician from Columbia Law School, a gentleman named Jeffrey Fagan, who looked at all of the documents. Every time there was a stop and frisk in New York City, there had to be a write-up of the stop and frisk in a form that the New York Police Department required. And even though much of it was the reasonable suspicion was made up, in my opinion often, they would say things like furtive movements, wouldn't look me in the eye if the cop's writing it up, or ducked away when he saw me coming, or those kinds of things. What Fagan did was take the basic things that could have been, I suppose, lied about or faked, but were not, and used them in a very effective way. So he took every stop and frisk on a minority kid, black or Hispanic kid, male, almost always, in New York City, because the police said, yes, of course we're going to stop more Hispanic kids, we're going to stop more black kids in the South Bronx, in Bed-Stuy in New York at that time. and in minority neighborhoods because that's where the crime is. That's why there's going to be more, numerically more minority persons who are stopped and frisked than Caucasian. And so how do you get around that? Well, Fagan took the statistics, and what they showed was that for every 10 stop and frisks of minority kids in New York City, there were 3 arrests. For every 10 stop and frisks of Caucasian kids, and for reasonable arrests, as you all know, it requires what? Probable cause, right? All right. So, and for every 10 stop and frisks of Caucasian young men or males or anyone, how many arrests were there? No, go up. 10. I mean, of 10, there were 8. 8 arrests for 10 stop and frisks, which tells you that there was a real basis for the stop and frisk when you're dealing with a white suspect, and color was the only basis when you're dealing with a minority kid, right? And those were hard facts that could not be avoided, and that provided the basis for the New York Police Department to then go back, and I looked at my watch because I'm worried about my time here, but we'll keep going as hard as we can, to then go back and retrain and say, look, you cannot use color as your basis for doing this. You have to have probable cause. You have to have reasonable suspicion that most likely is going to lead to probable cause, or forget it. Don't do it. And eventually, what was surfaced out of this litigation became the basis for a settlement with the New York City Law Department. With the city of New York, and the basis for the city of New York engaging in a widespread reform of the whole stop and frisk system, so that today the problem no longer exists. So that was one of the benefits that did come from effective litigation, and I point to it proudly, since I was involved in the beginnings and middle of that case, although not the end. And therefore, as a result of what we did, I think that we were able to strike a blow against structural racism and a blow against the school-to-prison pipeline. Now, I want to show you a case that I had before I went to New York right after I came from New York. This happened in 2006, and if I mess this up, I deeply apologize. Let's start with the beginning. The police stop a white, this happened, anybody here from Michigan? Okay. You know where Ypsilanti is, right? In Ypsilanti Township, which is, for the rest of those of you who do not know, a basically all-black community within Washtenaw County, which is a largely white county in Michigan, whose sheriff's deputies are almost all white. In this case, all of the deputies are white. And this is a stop that happened of a white motorist just outside of Ypsilanti Township, right on the border. Let's see if I can get it started here. Where's the arrow to click? Oh, here it is. Wait a minute.
Insurance, please.
Yes, sir. Can you hear?
I just bought the car yesterday. Okay.
He's explaining why he doesn't have license
Yeah,
plates.
I'm not shouldn't be out driving it, but I just drove a friend home. Okay. I dropped her off right there on Grove Road. You do what? Dropped her off right there on Grove Road. Okay.
That's an open container of alcohol, right?
All right, one step out of the car. Is there anything else in the car you're not supposed to have, Mr. Bell? No. No. Why don't you come on back here? Set your wallet right up on the. There you go. Put your hands up. Put them behind your head. Interlock your fingers. Where'd you drop your friend off on Grove Road at? Right there on what's it called? I don't know, boat thing and transfer or nothing like that. Oh, you're drinking going down the road, man. I wasn't. That's her. She was at my house getting lit. And then she got all stupid and left that in the car, so I wouldn't let her have it no more, and I forgot to throw it away. So okay, I'm going to see you real quick, okay?
There goes the evidence.
Somewhere about that, sorry, guys. You don't have to be sorry, man. You didn't mean. Yeah, well, we're doing our job, and you're being ignorant by not doing my job. So he's taking responsibility and doing what I'm supposed to do. If you obey the law, obviously. You just need to get your plate squared away. Get yourself some insurance in the car.
Bye-bye. These are emails that were sent among the sheriff's deputies that we discovered in the course of the litigation. Now, this is a young kid. This happened within 15 minutes of after the previous stop that you just saw.
And all your listeners have to do is grab a pen or a pencil. I'm going to give them a toll-free number, and I'll personally comp the first call to 3 days and 2 nights in Vegas.
That's your driver's license on your registration insurance?
877-5-FUN-FUN.
How could you not want to go to Vegas and get a room, deal, and have a great time?
You
I say
got
this
it.
all the time. If you can get a deal, even if you can't
license?
get a deal, you got to get out to Vegas. But with a deal like this, you have to get out there and do it.
Why don't you come on talk to me? I can't hear you or understand you.
I play golf there.
You don't have a license on you?
But I love this town. The best restaurants in the world, the best spots.
Turn off with your money back.
Hamper yourself to
Turn off
death.
with
Just
your money
shopping
back.
yourself the walls. And, you know,
All right, Tanya, give us that number again if you can.
sure. All you gotta do is call 877-5-FUN-FUN.
How could you forget that number, everybody?
You messed up, man? You alright?
This promotion is sponsored by
Good?
TV Village.
How come you can't talk to me? You sound real mumbly. Okay. Well, just chill, man. That's all it is. You'll be alright, okay? You got a license? Okay. You just suspended license. That's it. Is there anything in the car that you're supposed to do? Anything I need you're supposed to do? Okay. Okay, well, just chill, man. Chill.
Ford Hospital, along with Johns Hopkins University, is working on a program focusing on African Americans with Alzheimer's disease. To join the program, you must be 65 years of age or older, have visited a Henry Ford clinic in the past 2 years, and have been diagnosed with possible Alzheimer's disease. Please help us better understand the
Don't worry about it, man. Don't worry about it.
disease by participating in the Generations program. A passion incentive will be provided as well as assistance with transportation if needed. For more information, call 313-874-6229. Again, that's 313.
So the two brothers, Bruce and Clinton, see them coming in.
29 West. He says, why don't you keep walking then? Seneca, that's out there.
Let's see. Okay. The cops now have gone across the street to confront the two uncles.
What the fuck you doing? Back up! My motherfucker. Back up! I'm already back up. I'm already backed up, dog. You better back up. I'm already backed up. What's happening, man? Give me your hand. Why you fucking with my brother like that? Because he asked you to back up, and he didn't listen, so you better listen. I'll be right back. Give me your hand. Don't walk to him at the phone car. Give me your hand now! Well, I'm trying to let my brother go, man. What's wrong? Back up! You hear me? Back up or you going to? I'm already back up, there you go. Leave where you're going to. You better get out of here. I'm telling you. Yeah, I understand that. I'm telling you to get out of here. You don't get out of here right now, but you're going to see me again. Okay. Leave while you still can. Leave while you still can. It ain't going to be like this. Keep them coming. Don't put your hand in your pocket. Don't put your hand in your pocket. You're going to get dropped if you keep doing that. You're going to get dropped. It's a gun. Leave. 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 Don't take my shit out. Leave. That's what this is, dog. Leave. So they can take my shit? They're gonna take it out. Fuck, man, these cuffs. These bitches tight as a bitch. That's inside. Go ahead. We'll get a bus for you. Hey man, let that nigga go like that, guy. Man, let that nigga go. Yeah, don't looking up here like that. Man, get up off that nigga like that. Get up off that nigga like that. Man, they look down, man. I could have dipped on these bitches.
So, how many of them saw one of the cops call for backup as soon as the two uncles arrived? Did you see that? It happened. So now let's look at a little bit more of what happened to the brother who went around the corner.
I need to get out of here, man. Y'all arrest me for no fucking reason. Fuck you, bitches. Fuck the white man. Take me to motherfucking jail, bitch. Fuck you, motherfuckers. I don't need shit but my attorney. I don't give a damn! Bitch, y'all arrested me for no motherfucking reason. I told you I was leaving, man. I told you motherfuckers I was leaving, man. Fuck you, motherfuckers. Dirty bitches.
He'd been pepper sprayed.
Motherfuckers, you let me out these cuffs. I'm fine on one of you hoes. I don't give a damn. You damn right, bitch. You damn right. You motherfucking right, bitch. You gotta let me in that holding cell sooner or later. I'ma find one of you hoes. I'm not, I swear to God. Wait till I get in that bitch. Wait till I get in. I don't give a damn. Bitch, you ain't gotta hear shit else, you punk motherfucker. Watch when I get up in there. I ain't telling you whole shit. Bitch, what? Pull me out this motherfucker. What? Bitch, what? What? How about that stuff? Oh no. Did he just spit on you? What? Pull him off that side.
So he was sprayed and he spit inside the car. He's handcuffed, by the way.
Yeah. He's gonna bring some flex out. Fucking motherfucker. Yeah, damn, everybody just wants to run their mouth today. Yeah. Jesus, look for some in the water. Come on, Bob. Come on, what? I can't take no more. Come on, what? Too late now, too late. Too late. Come on, holding that. 29, Glenn. Contract. I'll find out these days.
Kneeling on his hat.
Come on, man. Lock me together and tie me up, man. Take me in. Yeah, I can't take no more. I can't take no more. No. There you go. Here momentarily. Hold on. This car is this just spit on my floor? Is this your car? Yeah, they're going it out like the rest of that. Spit on it. Here. Oh. Turn off your spotlight, Chris. Would you please? Oh, shit! To move this car. What the fuck? That's the car you can hang left. Yeah, right there. Are you after that? Are you after that? Are you after that? What for? Oh, shit! Yeah. Oh, fuck! Let's put him back in here. Oh, shit. You should have put him on the side, too.
I decided we don't, first of all, we don't have time, and secondly, it's probably too disturbing to show you the video of his brother who was followed around the corner and was basically pepper sprayed from a few inches, sat on the same way that Bruce was sat on, had his head pushed down against the ground and died of asphyxiation and positional asphyxiation. As I said, you don't want to see that anyway. But here's the point. These videos were taken, this was just as dash cams were becoming used by police departments. And they didn't quite realize what they were doing on camera, and all of this was captured. Now, these cops who killed Clifton Lee, and who beat up Bruce, were charged with a federal civil rights crime, because Section 1983 has a criminal side to it. That if you intentionally violate someone's civil rights, you can be criminally prosecuted for it. They were charged, and they were tried in front of a jury, and guess what happened? Acquitted is right. And in my opinion, I mean, there were a number of explanations for the acquittal, but in my opinion, one of the major explanations has to have been the fact that while the prosecutor showed the jury some of the tape that you just saw and others that you didn't, at length, they never showed the tape of the stop of the white motorist. And what does that tape show? Well, if you put the two together, what does it show? Anybody? Racism, intentional discrimination. It shows an intent to violate someone's civil rights, which is what you needed to show in the criminal prosecution. So the U.S. attorney, I think, kind of blew it, and I told her so later, although I don't think it did a bit of good, what I say. But I don't think it changed anything that happened in the U.S. Attorney's Office. But it's important to note that. Also, remember what I said, what are the three prongs of changing police behavior? Training, supervision, and discipline. And if you take this tape, how many of these guys should have been fired as a result of what you saw? Every one of them should have been. How many were fired? 0. And if you take this tape and just show it to people, you can demonstrate, again, as you could with the stops and frisks in New York, the power of racism in affecting the outcome of these individual confrontations. This kid, the first kid who was driving his car, who was handcuffed immediately, had done nothing wrong other than the fact that, I can't remember now whether it was an expired license plate or it was a turn signal light. That was it. He was never charged with anything. His uncles who came to see if he was okay, one's dead and the other was in jail and beaten severely. And this was all in their neighborhood. The mother had to watch all of it. Anyway, it was a pleasure to represent these folks. It was an honor to represent this family, which I had that honor. And obviously some money was paid so that they were compensated some, not enough, in my opinion. A new sheriff was elected. I don't know if this incident played a role, but it must have played some role. And unfortunately, and this is one of the things that's powerful about these cases, we never got a chance to depose any of the cops involved, or the sheriff, or the supervisors, because they put a lot of money out on the table very quickly, and the family simply couldn't afford to say no. But that is the power, I think, ultimately, the great power of Section 1983 litigation. It's the power to force public officials, important public officials, to sit there and answer questions. Why did you do this? Why did you do that? Why didn't you do this, that, or the other thing? Please explain. You have to explain. You have to answer, or else you'll be in contempt of court. There's a case called Scheuer versus Rhodes. I see that Professor McElward just left. Do you read that in that class? Has anybody read Scheuer? You read it. And that case arises out of the Kent State shootings, 1969, 1970, something like that, at Kent State University in Ohio, right? And Scheuer was sued, and it was alleged that he basically had given the order to pull the triggers. And what the United States Supreme Court ruled in that case was, if in fact that turns out to be true, then you can proceed with the litigation against him individually and overcome what's called 11th Amendment immunity. That is, that you cannot sue a state for damages. He has individual immunity as well. And the power of that would have been to force Governor Rhodes, in that case, to sit down in front of a court reporter and probably in front of a television camera and be forced to say, why did you do this? Why did you take this step? Why did you take that step? Why didn't you do a number of things that you should have done? Why were these kids and students at Kent State shot and killed and injured? Why? Explain it, Governor Rhodes. You tell us. And that's powerful. Any of you who have studied this know that one of the things you cannot, when a public official, when a police officer acts on behalf of a municipality, let's say in this case, these deputy sheriffs acting on behalf of Washtenaw County, Michigan, the municipality is not automatically liable. If I'm a professor at Notre Dame and I walk into class someday and one of my instructions is to teach lethal weapons, and I pull out a gun and I don't think it's loaded and I start shooting students out there, the university becomes liable through the doctrine of respondeat superior vicarious liability, right? That is not true in this area of the law. You have to show, the only way you can hold a municipality liable is to show that these acts happened pursuant to a custom, policy, or practice of the municipality itself. And that's a very limiting doctrine. And while we're at it, I just want to point out a few of the huge limitations in doing this kind of litigation. One of them is that you have to actually prove Monell, what's called Monell liability or custom, policy, and practice, rather than simply proving that the person was acting in the course of his or her employment. Another is what's called qualified immunity, that you have to show not only that someone violated your constitutional rights, but that when they violated your constitutional right, it was already a clearly established constitutional right, which forces or allows many courts and defense lawyers to come into court and say, well, there's no written opinion exactly on this point. There's nothing that says it's excessive force if you hog-tie an individual and then pick him up like a sack of dirt and then throw him in the backseat of a car. You have to have a case that says that. Then it becomes a clearly established constitutional right. Whether or not that's true is arguable, but that's a powerful defense. Another, of course, as I've just already mentioned, is 11th Amendment immunity. All of these things need to be changed, and they need to be changed and simplified for this law to really fulfill the purpose and the inspiration of the civil rights amendments. Another one, by the way, in proving a violation of the Equal Protection Clause, that the Equal Protection right is to show that there was an intent to discriminate. The mere fact that that the actions of government disparately impacted upon one group, which consists primarily of racial minorities, and did not impact upon another group, which was predominantly white, does not show intent to discriminate. You need to show actual intent to discriminate. So that, for example, in Flint, Michigan, which is a case that my law firm is working on with others now, if you show that the poisoned water that was piped into the homes of Flint residents was piped, or the poison was only piped into the homes within the city of Flint itself, a predominantly African American community, whereas in the surrounding communities to Flint, Genesee County, which are predominantly Caucasian communities, they continued to use non-lethal or non-dangerous water. That's not enough. That's the argument anyway. That's not enough to show intent to discriminate in a violation of due process. These things have to be gotten rid of. There's a famous case called Connick versus Thompson. I don't know if any of you read it in your civil rights class. This involves the failure to produce Brady evidence, that is exculpating evidence in criminal cases and thereby causing innocent people to get convicted. That's what happened to Mr. Thompson. And what was alleged in that case was that there was a failure to train. Failure to train constitutes a custom, policy, and practice under Monell, and therefore, given that failure to train, there was a Monell violation. It went all the way to the United States Supreme Court, and Mr. Justice Thomas, writing for the majority, said, well, anyone who's gone to law school knows enough not to violate a person's Brady rights. You're all in law school. Do you think you've been sufficiently trained on the elements of Brady and knowing what can and cannot and needs to be sent to criminal defendants and their lawyers? No, a prosecutor's office has to start really teaching its members what they can do, what they should do, what they have to do, and what they're morally and ethically bound to do. And by the way, that the prosecutor's office, rather than the prosecutor himself, was sued because there's something called prosecutorial immunity, another huge immunity that you have to get around these cases. You really can't sue prosecutors at all for violation of constitutional rights. But in this case, the lawyers were smart and they didn't sue the prosecutor. They sued the county on a Monell basis, saying that it was the county's policy or the policy of the prosecutor prosecutor's office in not training that basically triggered liability. All of these things that have to be circumvented and got around are huge problems, as I said, in fulfilling the purpose and meaning of the 14th Amendment and of Section 1981, the Civil Rights Act of 1871. And without belaboring it, there are reasons why courts are reluctant to extend liability against police officers in many situations. They don't want to tie the hands of the police. They don't want to tie the hands of prosecutors. They want to allow law enforcement to continue to do its job, to continue to enforce the law and catch criminals and prosecute criminals. But nonetheless, the statute should have meaning that gets you past many of these encumbrances and fulfills the congressional intent of that abolitionist Congress of 1871. I'm just about to end. So with that in mind, I guess I'll end on this note, that even with those roadblocks that I just described, the important thing is still that you can force government to answer for many things that it does that are wrong and unjust. You can force important people to answer questions. Why did you do this? Why did you do that? Why did you do the other thing? It's not exactly speaking truth to power. I would call it rather demanding truth from power. And in and of itself, that alone is, I think, an important rationale for doing the kind of work that some of us do and for the Civil Rights Act of 1871. Thank you very much.
Everyone, if you have questions, take questions till 1:45. Feel free.
Questions? Yes.
You mentioned that the training.
Could be.
I mean, that isn't the first time that I've heard that. Has a lot of merit. Proposed and spoken on. Share. Actually making an effort.
I think mostly it did not happen in Washtenaw County. The new sheriff did not, as far as I know, use any of what happened to this family as a way of training his cops. But I don't know whether there has been more conscientious training, supervision, and discipline in Washtenaw County or not since then, because I haven't had a case against that department since then. I'm fascinated and would love to know the answer to that. In some departments, it's made some difference. There is more, I think, in the New York Police Department, as I said before, there's more thought that goes into stops and frisks before they're undertaken, and conscious attempt to avoid blatantly racist decisions. I think that does happen now. In other departments, well, we're seeing so much now in terms of police misconduct and shootings in Baltimore and Charleston and all over the United States that, and you hear at least chiefs saying this is what we need to do, this is what we need to undertake. Up until this, let's say 2 years ago, I've seen little evidence of it. There seems to be more now, and we'll just have to see how much of this gets curbed. Certainly the existence of media like Facebook and all sorts of other YouTube and all of that kind of thing has made some difference. So I guess my question is maybe a little, but not a lot. Yes, next, and then you, Rashid.
Have you thought of in police departments? Because I feel like on the department, but on the other hand, we hear a lot of talk about, having a lot of cities that complain that they would be firing these officers if they already are short on officers. What is your
Well, certainly in terms of, especially on issues and incidents of racism, diversity in hiring is obviously very important and has to be undertaken. Certainly not the end. I have a case right now involving a young man who was a boy when he was arrested, 14, who was literally framed by 2 African-American officers and sent to prison for 9 years for a crime he absolutely did not commit. And the evidence was sat on by these cops and by the prosecutor in Wayne County, which is where Detroit is, and who also is an African-American woman. So diversity isn't always the answer. It's a part of it, consciousness, and I think the idea that someday they're going to have to answer questions and be forced to come up with coherent, intelligible responses makes some difference. As far as doing the training itself, they never asked me to come into the police academy to.
That's the question, how would you ultimately reshape the culture? Because a lot of the time, is it really just or is it more realistic to say from the way that we're hiring and getting them started? The entire profession itself, like
So, that's a great question. I don't have a great answer to it. You know, I assume that they hire anyone who's basically able-bodied and stands up and says, I can do the job, and reasonable intelligence, and then that person gets sucked into the culture you're talking about. How you change that culture? I think that's not the lawyer's job as much as it is all of our jobs as a political community and beings. Yes, Rashid.
So, culture. What is the role of the National Lawyers Guild? The national chapter of National
What's the?
What was the role of the National Lawyers Guild?
The National Lawyers Guild is an institution of a small bar association nationally, but the lawyers in the National Lawyers Guild do some of the really important work, especially in this area. The case that I talked about, Monroe versus Pape, was handled by Donald Moore, who at the time was a member of the National Lawyers Guild in Chicago. The stop and frisk case in New York was handled by lawyers from my group, the Center for Constitutional Rights, almost all of whom were members of the Guild. And the Guantanamo cases are all the same. So the Guild is in the forefront in the sense that in terms of these cases, which try to change the world, shape culture, do things that are important, Guild lawyers are doing it. So that's what I would say. Yes, Terrence had his hand up over there.
I just had a quick question. I had problems with the specific. A couple summers is shooting.
That's where I grew up, by the way. I never got, nobody ever put handcuffs on me. I wonder why. So, because what's your question? What can be done to prevent it?
Like at the time, because I would rather have my hands at my side.
Of course. Well, one thing, did you file a complaint with Internal Affairs?
No, I figured,
You didn't want to look for more trouble, right? Well, that's one thing that you could or should think about doing anyway. How long ago was that? And by the way, he's absolutely right. A judge got shot in that neighborhood. A federal judge got shot in that neighborhood. So, I don't know the answer to that, but come and see me. We'll figure something out. Yes.
If a low-income
Well, what kind of incident are you thinking about?
Well, 2 years ago, this violation and caught by the police. But they had to unzip his. Now they're covering it up and jury trial.
The young man was charged with a crime?
For attempted murder to officer.
And they don't have, well, he needs a good lawyer, first of all, to force there is criminal discovery, there's stuff he should be getting. Does he have, what?
The problem is this is a low-income family afford a big lawyer.
Yeah, that's a problem.
And his court-appointed lawyer is the hired person. What can this family do to find help to keep definite proof, and they won't allow it on the police video.
Judge won't allow it in court? I
They
mean,
probably won't, because they're not gonna go to a jury trial, and the lawyer.
you mean the
won't-
lawyer's trying to get this person to plead guilty?
Yes, they want to make a plea. Where can you go? Is there anywhere?
It's really hard. Is there a legal aid society in that vicinity? Are there lawyers who take on cases on a public interest basis who might be willing to take it? Go to someone who's conscientious, you know? Ask around. I don't know how to help you on that kind of. But that's a terrible problem. It happens all the time, by the way. Yeah.
So in our civil rights class, we were talking about and as a group nominated, what would the effects be if this were to happen?
Reversing Monroe versus Pape?
Or welcoming to overturn it, yes.
Everything I just talked about would then be basically flushed down the toilet, be gone. And it is a danger. It's a huge danger. So, I mean, that's one of the reasons why, with as flawed and faulted as this is, this election is important. You bet. Let's see. Do we have time? It's.
Yeah, we can go to 45.
We can go to 1:45. Okay. Yes.
So, in my undergraduate degree, I was a student of German culture. Movement that is called Wiedervereinigung, which is a past where literaries, politicians, and the German culture as a whole really grappled with what happened during the Holocaust. Because for the 50 years following that, no kid wants to talk about how their parents are monsters. No grandparent wants to talk about that with their children. But this time period after the Berlin Wall fell was a really big moment in German culture. You talked a little bit about culture and how it plays into this conversation. And frankly, you have two major nominees for president that have not taken this issue seriously. How would you recommend that us as students of civil rights move forward the conversation in the future?
Well, one of the things I suppose you can do is try to get involved in these kinds of cases, this kind of litigation. How many of you were really deeply affected by the DVD that I just showed you? Everybody, right? Yeah. So if you get some of material like that and you're able to go to law schools and go to community organizations, show it, get it shown on TV, put it on YouTube, whatever, that will have a profound effect in changing things, maybe even change the police culture. Who knows? I mean, people do get shocked. Even, I shouldn't say even cops. I do believe that there are many good cops who want to do the right thing, but who do tolerate an intolerable culture of police violence. Yes?
do you fight those kinds of battles to not have more information's there, but no one's going to give anybody access to it?
In other words, they're talking about putting in an exception in the State Freedom of Information Act that
Allows them to restrict access if they think it might harm someone who's in a video, and you'll never, you might be able to see it, but you won't be able to have a copy of it, and all that.
Well, I suppose if you actually get to see it and it shows something that is a clear violation of someone's rights that's resulted in either an arrest or a beating or a conviction even, false conviction, it can become a lawsuit, and then you have the power of subpoena to get those records and you can obtain them. That's the best I can think of. Whether if the Indiana legislature puts that exception in the Freedom of Information Act, I think you're stuck with it, unfortunately. I don't see a constitutional challenge to that, which is, yeah.
So just like you showed this dash cam, and there's been a lot of introductions like that, body camera footage, and there's a whole slew of new, I'm a 1L, so I haven't taken evidence yet, but there's a whole slew of new technologies and evidence that can be put forward that, frankly, the majority of the population of this country, because they didn't grow up with it, they're not familiar with the technology, and frankly, a lot of the Supreme Court justices don't even know how to use email. How can we trust...
Wait a minute. How do you know that? That doesn't sound right to me.
Ginsburg said that in a timepiece.
Oh, right, that's true.
So how can you trust judges, commissioners of a generation that doesn't understand technology to appropriately gauge the sufficiency of that?
Well, I never trust judges. I shouldn't say never. I don't have a lot of trust in judges or in the judiciary, with a few exceptions. One of which was, by the way, the judge who decided the stop and frisk case that I talked about, who was badmouthed during one of the congressional debates by one of the candidates. She was called, she's bad on cops, I think was the phrase that I seem to recall Mr. Trump saying. But I trust her. She's a great judge. But I don't know that you can trust them to really understand. I mean, you've got to, as with anything, the lawyer's job is to try to educate either the jury or the judge. So you've got to really work at it. Prepare a motion that's understandable, that's readable, that makes sense, and say, I'm going to put on testimony, and you'll get it. And then put it on in a way that's understandable. That's all I can say. So, yes.
I'm Castle, I'm faculty here.
Oh, yeah.
I don't remember, I was president of the Chicago chapter of the Guild back in the 80s.
I do remember. It's nice to see you.
It's good about the economics, because part of this talk is about terms for lawyers in Detroit.
Yeah, I would, at the most, I would say half a dozen. How many in Chicago do you think? Yeah. So maybe, yeah. So now a lot of, it's highly specialized. A lot of lawyers don't want to do it. It's hard. You have motions. You have something on the qualified immunity, which I mentioned before. If there's a qualified immunity challenge, the defendants get an automatic interlocutory appeal to the Court of Appeals on these, which delays things forever, and these become hugely burdensome economically, so it's tough. Very few. Once you develop a taste for it, though, it's sort of like an addiction, I guess. You can't let go of it. I can't anyway. All right, I think yes.
Others just tell me that it's the other thing is conflict of statutory law and common law, because
they claim that we have constitutional rights. Statutes are color of law.
Well, no. The phrase color of law is a phrase in the statute, section 1983. And all it means is that you're acting, that you are clothed with authority. So if you have a uniform, a badge, a gun, a license to carry the gun, and a title, and you break into the home of your girlfriend's other boyfriend and shoot him, which this is not an unusual situation, by the way. I mean, it's not. It's reported. You're acting under color of law, even though you're motivated purely by personal things. So that's color of law. I don't understand quite. I think the Constitution, in a sense, is statutory. It's language. It requires definition and.
Mulberry versus Madison. It's like, with the statutory law, they bring in the complaints. And with the common law, it's a claim. And the claim is directed at a point. Where's my accuser? Bring forth the person that I have injured. Statutory law dances around the issue. And they can throw it in 1,000 different directions.
Okay, I don't really, maybe what we should do is talk about this outside of this context, because I think it's time to call it a day here. What? Well, is there anyone else? Okay. Well, thank you very much, everybody.